Good morning and welcome to this morning's webinar about changes to the Family Law Act, what's changed and what you need to know. My name's Catherine Gorder. I'm from the Community Legal Education team here at Legal Aid. I'm going to start with an acknowledgement of country. So Legal Aid Queensland acknowledges and respects the First Nations custodians of the land where our offices stand and where we work to help disadvantaged Queenslanders uphold their legal rights in our justice system. We pay respects to their elders, law, customs and creation spirits, and we recognise that these lands have always been places of ceremony, teaching, research and learning, and we acknowledge the important role Aboriginal and Torres Strait Islander people play in our community and in improving our legal system. So again, welcome to this morning's webinar, Changes to the Family Law Act. There's a few little pieces of housekeeping I need to run through first before we kick off. First of all, I'll introduce our presenter today. So this is Marianne Hutt. She is the Assistant Director of Family Law here at Legal Aid Queensland, and we're delighted to have Marianne with us today. Thank you. So some housekeeping first off. So this webinar is being recorded. We will be putting a recording of this webinar on Legal Aid's YouTube channel, and we'll email you about that a couple of days after this webinar, so look out for that. If you need any IT help with your webinar today, please go to the GoToWebinar customer support link. Unfortunately, we can't provide that help to you during the live webinar. A few more pieces of housekeeping. The structure of today's session will be a 40-minute presentation, and there'll be time for some questions at the end of the webinar. So I encourage you, if you have any questions you want asked, to type them in the question box on your screen, and we'll look at those towards the end of the webinar. We have attached a few handouts for you. There's a copy of the PowerPoint slides. There's also a copy of a leaflet we have that lists all the different types of legal problems Legal Aid Queensland can help with and the ones that we can't. It's just a useful thing we like to share with our stakeholders. There's also a table handout that lists the types of services we provide, everything from free legal information, advice, our due lawyer service and representation. So if you want to understand a little bit more about our services, have a look at that one. So we're going to kick off first off with a poll. So our first poll is just to find out a little bit more about our audience who's attending today. So I'll just launch this one for you so you can answer. So the first question is, what region do you work in? South East Queensland, Far North Queensland, Regional Queensland or outside of Queensland? So if you could please answer that, I'll give you about 10 seconds. Okay, a couple more seconds. I'll close that and share the responses. So most of you are joining us from South East Queensland, but we've also got some representation from Far North and Regional Queensland as well. So that's great. And a couple from outside Queensland as well. So welcome. Our next poll is asking, what is your role? So I'll launch that one now. So the options here, support worker, financial counsellor, health or education worker, social worker, lawyer or other. So if you can choose your answers for that one, I'll give you another 10 seconds. Okay, a couple more seconds. Great, I'll close that and share the results. So half of our attendees today are lawyers, that's great. We've also got some support and community workers and some social workers and some financial counsellors as well and other. Thank you for that. And one more poll. This one is to find out about your knowledge of when the Family Law Act last changed. So I'll just launch this one for you now. So the question is, the parenting sections of the Family Law Act have changed a few times since 1975 when the Act first started. What year was the last big change? Yep, so a few more seconds. Okay, close that off and share. And Marianne, is the correct answer C?
The correct answer is indeed C. The last big changes to the parenting sections of the Act were in 2006. And when Attorney General Mark Dreyfus presented this Amendment Act to Parliament, he said the new laws are informed by more than 24 inquiries into the family law system over the past 9 years. And he also commented that those inquiries indicated that prior to this change in the legislation, Australia's family law system was not working as it should.
Okay, so what we'll be talking about today, we'll be looking at what's changed in family law, how the court decides parenting disputes, the focus on best interests and safety, what the court can do and what when court orders aren't followed, and new powers to prevent harmful litigation. Okay, I'm going to hand over to Marianne now to deliver her presentation.
Thanks, Catherine. So I guess I just wanted to start with an overview of what's actually changed in this recent legislative change for the Family Law Act. So there's some fairly big changes across the parenting parts of the Family Law Act. So there's been some changes to the parenting framework. So when I say parenting framework, I'm referring to the legislation which talks about how parental responsibility and how children spending time with parents and others, it has been changed. Also, there's some changes to the sections about when there has already been either agreement/consent orders for a family and they need to come back to the court to make changes to previous final parenting orders. The Family Law Act has changed in some respects around those sorts of decisions. There's been some changes in the way the court can enforce parenting orders. So if somebody doesn't comply with the parenting order, the court has got some different ways of enforcing those parenting orders and different things that they can do when those orders are not complied with. There's some changes to what independent children's lawyers need to do when they are appointed into a family law matter. There's also some changes and new processes and decision making around when harmful proceedings happen. So harmful proceedings are when one of the litigants in the process is using the proceedings as a means to control and intimidate the other party. So the legislation has changed to make it the court give the court more focus in those sorts of proceedings and some new ways to enforce the process properly. And then there's some more things that I'll talk about towards the end around what's next in the Family Law Act and some changes that might be coming in the next 6 to 12 months. So when we're talking about the parenting framework and parental responsibility, the old Act had this quite convoluted set of expectations and decision making. Lawyers used to call it the pathway. And so you started out with equal shared parental responsibility as the start point. And then if there was arguments about why that wasn't appropriate in a particular case, then you worked down the sections to work out what the proper arrangements are. The changes to the Family Law Act have removed all of that, and the start point is that there is no presumption for equal shared parental responsibility. The Act does say that parents do have a responsibility for decision making around their children, subject to the court making an order that changes that. What the Act also says is that parents should, if it is safe to do so, consult about decisions for long-term issues for their children and make a genuine effort to try to come to some sort of agreement. And parents should think about the best interests of the child when they're coming to those decisions. So if the parents are not in court and there's no issues around safety, then I would expect that parents might decide that they come to some agreement jointly. But if the parents are in conflict and they need to go to a court, the court can, in the evidence, taking into account the evidence and so on, come to an arrangement or make an order for either joint, both parents have to be consulting with each other, or sole responsibility for one parent. And that decision making can be specific. So it may be that the court could make a decision that one parent has sole responsibility for a particular thing, like the educational needs of a child or the medical needs of a child. So the changes to the Act has made it simpler and more straightforward for parties to understand, but also for judges to make decisions around that. There's always some overriding considerations, and the changes to the Act note those overriding considerations for both the court and the parents. And that is that the best interests of the child or the children are met by ensuring their safety, prioritising their safety, and also giving effect to the United Nations Convention on the Rights of the Child, which is a convention that Australia has signed up to. That's quite a long convention. There's a lot of sections in there that are applicable to the family law sphere. But basically, I think inclusion of that reference in the Act ensures that the focus is always on the rights of the children in these sorts of decision making. The next big change, of course, following on from parental responsibility, is around changes to the legislation around the time children spend with their parents and others who are important to them. So the presumptions that were in the old Act, similar to parental responsibility, have been removed. So there are no presumptions about equal time or significant or substantial time in the Family Law Act now. So when parents and judges in court have to make decisions about what time children should spend with each of their parents and others important to them, Section 60cc of the Family Law Act is the one that lawyers look at. And so there's a list in the slide there of the things that are set out in that section. And first and foremost, it's around safety, not only of the child, but also for the carers and the parents. That's a significant change from the old legislation, in my view. So the safety of the child and carers from violence, abuse and neglect is the first part of Section 60cc. So that suggests that it's a fairly important consideration. The other things that the decisions need to consider are around the views of the child, the needs of the child, and there's a list there of emotional, developmental and cultural needs. That's a shorter version. If you need to, you can certainly look at the Act to see what the longer version of that is. The court also and the parents also need to consider the capacity of the parents to provide for the needs of the child, an examination of the benefit of the relationship for the child with the parent, with the focus on the safety of the child and carers in that decision making. And the Act also has a catch-all provision which says anything else that might be relevant to the consideration around decisions around time. So there's some primary considerations for all children, and that last dot point on the slide is a note that there is extra considerations for children who are Aboriginal and Torres Strait Islander children, and they're extra considerations for those children in the litigation process, or if families are coming to agreements on their own, that those children need to be, that the decision making should also take into account ensuring those children's connection to their country, culture and language as part of that decision making. The next big change that has occurred is in those cases where there have been final orders made in a previous set of proceedings, or final orders made by consent between parents previously, and for whatever reason, one or each of the parents want to change those final orders. The legislation puts in place what lawyers have referred to as codification of a case. The old case was called Rice and Aspland, But this Act has now put the processes and decision making that was set out in that case into the current legislation. So the legislation basically says that the court must not consider final orders or reconsider final orders unless there has been a significant change in the circumstances since the making of those final orders, and it is in the best interest of the child to allow the restarting of another round of litigation around parenting orders. So I think the thrust of putting that section into the Family Law Act is to try to stop cases from coming back again and again. Sometimes, litigants want to have another go, or, they're unhappy with the decision that was made and want it changed. And I think this is an attempt to limit the means by which people can come back to have another go at decision making around parenting, and to potentially also limit the risk if one of the parties is utilising the litigation as a means to keep in contact or to control the other party. So the next sort of bigger change is around when somebody doesn't comply with an order of the court. Lawyers call that enforcement of orders. And so this part of the changes to the Family Law Act is around making changes to the enforcement of orders for children to be time with them. Essentially, it makes clear that there are some significant consequences for parties who are not complying with court orders for children to spend time with their parents. So an enforcement application is for parties when an order hasn't been complied with, and someone, usually the party who is not getting the time that they're supposed to, or if there's some issues around decision making and the other party isn't making decisions in the appropriate way, then they can bring an application to court to have that person dealt with for failing to do what they're required to under the existing court orders. So the legislation allows for people to be excused for not complying with the court order in certain circumstances. And on that slide, I've set out the circumstances. And they're basically, if someone didn't properly understand the order, and there'd need to be some evidence of that, usually that person would need to put in an affidavit to the court saying, I didn't properly understand that that was what the order meant. And if that is the case, the court can say, okay, we're probably unlikely to get punished for that, but the court does have an obligation to properly explain the order to that person to ensure they do understand what it means and what their responsibilities are to comply with it. The other excuses that are available if somebody doesn't comply with an order are sensible as well if following the order isn't reasonable and there were issues around protection and safety of the child or another person. But that exception is only allowable for as long as it was necessary to protect the safety of the child. So it's not an open-ended excuse. It's only for the purposes of a risk that was time limited, in my view. And the other excuse, the other thing that you need to know about, or parties need to know about if they're making an excuse, they need to be able to prove with some evidence that they have that excuse. So if a party has contravened an order, the other person starts up proceedings around enforcing that order, there will be some responsibilities to provide that evidence in the usual form, which is an affidavit that needs to be filed in the court. And continuing on around enforcement, there's some early intervention that the legislation allows in this space as well, which is something that wasn't available with the previous legislation. So if someone does start up a case to get enforcement of an order, without making any finding, without going through any particular decision-making process, the court can order some make-up time, which might actually mean that, you know, if somebody's missed a couple of weekends of time for whatever reason, the court can just say, okay, I'm going to order makeup. The court's going to order some makeup time. And that might resolve the issue around enforcement. So that's a quick way for the court to be able to fix the problem without lengthy litigation resulting. They can also make an order for a person who's involved to attend a parenting program. Again, that might be a quick fix for that parent to gain some knowledge and understanding about why it's important for children to spend time with each of their parents so long as it's safe. And that might be a quick way to overcome whatever the issues are with compliance with orders. And the court can also, again, without making any findings about whether or not somebody's done something that they shouldn't have, make a variation to the orders so that they might work better practically. So potentially changing some times, changing some changeover arrangements, those sorts of things I think are the likely things that the court could do in this space. And that might mean that the case for enforcement of the orders that was brought by the party who felt aggrieved by it might not continue. So I think they're sensible changes to the legislation in that circumstance. So as the slide says, court can make these orders at any time without having made a decision about whether someone did or didn't comply with the orders. So this next slide is about the consequences of non-compliance with orders. So if the court goes through a process of hearing or getting evidence from the parties on affidavit, and after that process, and that can sometimes, you know, see one of the parties be giving evidence in a witness box and being cross-examined. But if the court is satisfied that the orders were in fact breached, and there wasn't a good excuse or a reasonable excuse for that person to breach the orders, then there's a two-tiered way that the court can deal with the punishment that should be imposed. So if it's a lower breach, so it's a breach that's happened but the court is not satisfied to say the criminal level of proof, which is beyond a reasonable doubt. If they're satisfied that it occurred but it's not at a criminal level, then they can impose lower penalties. So a bond, so asking the person to make a promise to the court that they won't do this behaviour again, and or in some limited circumstances imposing a fine on the person who's breached the order. The court can also order the reimbursement of any expenses which have been incurred by the other party resulting from the contravention. So, for example, in my mind, if somebody, you know, had to be paying for a contact centre changeover, or if there was some flights that were, you know, not, the child wasn't put on a flight to go to the other parent for the time, that might be something that could be reimbursed to the parent who paid those. So that's another punishment that can be imposed. And if it's a very serious breach and the court is satisfied to the higher degree, so beyond a reasonable doubt, then the court can impose quite significant penalties, larger fines, and, if appropriate, imprisonment for the person who breached the orders. So they're quite significant impositions and punishments. So I think the court is, the legislation is trying to demonstrate that compliance with orders is important and should be taken seriously. Of course, as always, the court does have an obligation to consider the impact on the child of any of the penalties, as well as considering how serious the breach was. So I think that section of this part of the Act is sensible because it it would be silly to put a parent who is the primary carer of a child in jail for breaching the orders if that was going to have a significant impact on the child. So there's always that possibility to take into consideration for the court.
We have another poll. So I'll just bring this up on everyone's screen now. So the question is, what age do children get to decide about who they live with and what time they spend with their parents? So if you'd like to pop an answer in the box there, the options are 12, 14, 16, and it depends. So I'll give you another 5 seconds.
I have to say, as a family lawyer, that's one of the things that people who aren't family lawyers ask quite frequently. They're always interested to see what the answer is.
Okay, I'll close it off now. So the vast majority have said it depends.
Oh, winning! That's the exact right answer. I was just going to say there was a case a few years ago that went to the High Court, and the end result, it was a complicated legal argument, but the end result was that a 17-year-old was actually ordered to live with a parent despite the fact that that 17-year-old had very quite strong and vocal views that they preferred to live with the other parent. So I guess that's just a demonstration that even as old as 17, the family court made a decision that was very firmly against the clear wishes of a 17-year-old. So one of the other big changes in this legislation were around ICL, so independent children's lawyers practice. It's never been an absolute requirement, but I think it's probably been a reasonable expectation for some of the judges in the family courts that independent children's lawyers should meet the children that they are representing. So for those of you who don't know what an independent children's lawyer is, an independent children's lawyer is a lawyer who is appointed to represent the best interests of a child. So it's not a client-lawyer relationship, it is a best interest representative for the child in the family courts. It's got an analogous one in the child protection courts. They're called separate representatives. But in the family courts, it's never been a requirement for ICLs to meet with the children, but there is now a legislative requirement that, subject to some exceptions, which we'll talk about, independent children's lawyers should meet the children that they're representing. And the exceptions are where the children are under 5 years old. So I guess that's an age at which they may not have a full and complete understanding of what might be occurring in the litigation and may not have an ability to express a clear view. And also there's an exception for exceptional circumstances, and that's set out in the Act around risk. So a risk to the child which can't be managed, or that meeting with the independent children's lawyer would have a significant impact on the child. And of course, because this legislation has only been in force for a short while, we don't actually have much information of what those things might look like. In time, I expect there may be some cases which come out, but I guess we'll just wait and see about how that plays out. But for now, independent children's lawyers are required to meet with the children they represent. If the independent children's lawyer does come to a conclusion that the exceptional circumstances exist, the court needs to agree with that. So there will need to be a process whereby the court makes a decision that the decision to not meet with the child was appropriate. And the section also says that if the court does come to the conclusion that the ICL's decision not to meet with the child wasn't appropriate, then they can make orders to ensure that that does actually happen. And the other change for independent children's lawyers is around Hague Convention proceedings. For those of the non-lawyers in the audience, lawyers talk about Hague Convention proceedings. That's when children are either taken out of Australia by a parent to another country who is a signatory to the Hague Convention, and the courts are seeking the return of that child back into Australia. So parenting proceedings around their care and what arrangements are appropriate for them can take place in Australia. Similarly, if a child has come into Australia from another jurisdiction and that country is asking for the return of that child to that jurisdiction so that their family law process can happen in that country, this part of the legislation enables an independent children's lawyer to represent the best interests of the children in those proceedings. That is not something that's previously occurred. Previously, Hague Convention proceedings were really seen as quite procedural, as a decision about which is the home country that a child should be in for the purposes of the family law proceedings about their care arrangements. But I think this has changed realistically to ensure that the views and wishes of the child in those proceedings can actually be heard and taken into account in that decision making. This is one of the more interesting changes to the Family Law Act, and it's bundled under the heading of harmful proceedings. But basically what it is putting in place some structure to manage where a party might be using court proceedings to harass or control the other party. We used to call it, in the family law sphere, vexatious litigants, and the old section of the Act was termed, vexatious proceedings, and the people were vexatious litigants. This is the legislation continues with that theme, but provides a much more detailed view of it and breaks it down into different types of these sorts of harmful proceedings. And as you can see on the slide there's three types. An unmeritorious proceeding, so a proceeding that's got no prospects of succeeding. A harmful proceeding, so that's around the impact that it would have on the respondent, the other party in the proceedings, and the child, so the harm that might be brought about by the proceedings continuing. And vexatious is, of course, what it says on the label, somebody who is a serial litigant, somebody who's got proceedings in lots of courts for lots of reasons, and the one in the family courts is just one of a vast swathe of proceedings that this person has engaged in. So it's a pattern of behaviour for a vexatious litigant. So the court now has some responses to each of those types of proceedings. So if the court sees an application as unmeritorious, so it's got very little or no prospect of succeeding, then the court can dismiss the case right at the beginning, and that then stops the proceedings going any further. And of course, that has the benefit to the other party of not having to engage with that, and of course, not have the stress of being engaged with it. And again, also stops the other party having to engage lawyers and potentially the expense of being involved in the proceedings. In terms of harmful proceedings, the provisions of the Act allow the court to stop a person or prevent a person from starting a case if, on the evidence, and I imagine the judges and decision makers will be taking into account the history of the previous proceedings, they can stop a person from starting a case before it actually starts. And I think that, for the lawyers in the audience, you'll remember there are some cases that were decided around that where judges will make orders that they can't start a proceedings. They need to, file it before a particular judge before they can then serve it on the other party and start it properly. So that is, I think, what is going to be happening in the harmful proceedings space, that those litigants who do have a history of using proceedings to coerce or control their other party, they will be dealt with by the court, and it seems likely from this section of the Act that the proceedings might not even be notified or be able to be served on the parent, the other parent, in that circumstance. And of course, I think the old provisions of the legislation are roughly similar to the current new provisions of the legislation around vexatious proceedings. So a court can stop a person from starting a case if they have a history and make an order such that if a person does want or have what they think is a legitimate reason to restart a case, it will need to be overseen by a judge before it is then allowed to continue and be served on the other party. So that's the changes for harmful proceedings. And again, no cases yet out of that. It's something that we're going to have to wait and see how the court manages. But it certainly seems to be ensuring safety and preventing harm from these sorts of proceedings for the respondents in this space. So the next slide that I've got here, and we're coming to the end, so I hope you've got lots and lots of questions.
This is a good point to remind everyone. Please, if you've got questions for Marianne, please type them in now, because we'll be moving on to that section pretty soon.
I want to say that there is a lot of resources out there. There is a very good brochure. The one that I've put the link to there is the simplified brochure for clients. There is another brochure on the Attorney General's website about for lawyers about the changes to the Act. And a couple of months ago, when this legislation first started in May, the Attorney General, through the Family Law Network, put out a series of YouTube videos, webinars, which the links are to there, about each of the changes and each section of the changes. They were designed for lawyers, I have to say, and they are quite legalistic. But if that's something that you're interested in, I can recommend them to you as a really good resource to understand.
I was just going to point out that all of the links on this slide, we'll make sure we include all of those in the email that we send to you with the webinar recording in a few days' time. So yeah, you'll definitely get copies of all those links.
And can I just say, while we're on this slide, there was a question that was sent in during the course of the lead up to this, and I think the question was about around whether or not parents have a 50-50 care arrangement, and that there is the possibility of child protection becoming involved in a family, and what might happen in that circumstance if child protection is concerned about one of the parents. I guess in our experience at Legal Aid is that person probably needs to get some legal advice fairly swiftly, but in general, if there are family law proceedings on foot or just about to start, child protection can become a party to the proceedings in the family court if necessary, or they have the option to provide information about that family and the concerns that they may have in a child protection sense to the family court, so that the family court has that information and can take account of that information in its decision making. But it's always important to understand that if the Child Protection Agency decides to take an application to take the child into care in the state courts, so in the child protection courts, then any family law proceedings have to stop and be paused at that point until the child protection proceedings are finalised.
Okay, I'll click on the next slide. So this is just a summary slide about some of LAQ's services. In one of the attachments I mentioned earlier, it gives a quick overview of sort of the levels of legal aid services. So anyone can call Legal Aid and get free legal information about their legal issue. If we feel that they need to get some legal advice for a lawyer, we then book them in for a free legal advice appointment. Subsequent to that, if it's determined they need ongoing legal representation, there's the option to apply for a grant of aid, and that's that process to get ongoing representation with their matter. We also have duty lawyers in a number of courts around Queensland, in both in both the criminal and the family law space, providing free legal assistance to people appearing in court that day. We also do take referrals to community legal centres and private firms. So have a look at the attachment that I mentioned earlier, just for some more information about our services. But the next slide.
Can I give a shout out to our family law duty lawyer service for those of you who are going to be potentially referring clients to our family law duty lawyer service. We have somebody at the family courts in Brisbane every day. We also have a phone line where people can seek duty lawyer advice up to 5 days before their court event. That's because a lot of the court events in the family courts currently, at least early in the proceedings, are happening via a Teams link, and sometimes people don't realise that they can get legal advice prior to that day. So if you do have clients that you're referring, they can get a duty lawyer advice up to 5 days before their court date. So, and you can access our website. There's a 1300 number for that service.
So we have had a couple of questions come through from our viewers. So the first one is, in terms of drafting for orders for parental responsibility, is it appropriate to still draft as sole parental or joint parental responsibility as would have been done prior to the amendment?
This is a moving feast, I have to say. I'm sorry, again, I don't have a clear answer for that because at least in our experience at Legal Aid, we've seen a number of different ways that this has been drafted by different decision makers since this legislation has come into force. I think it's likely that there will be a settled position at some point when we get a decision from one of the higher courts, so an appeal decision around that. But currently, we're seeing orders that do mention sole and joint parental responsibility, but it's not very clear whether or not that will be where the court lands eventually. So it's a kind of difficult question to properly answer. I'm sorry, but each of the judges and decision makers have a slightly different take on what the orders actually should look like.
Okay, thank you, Marianne. We've had another question come through. This is someone saying, I have a number of clients with children in their early teens who have been refused visitation by the other parent, which has ultimately, after a period of time, led to the child voicing they do not want visitation. Will the legislation enforce visitation for a 12 to 13-year-old if there were no safety concerns?
So that's a double question, I think. One about, that age question about when children get to decide or have, when their views are followed by the court, and also a second part about the potential for enforcement of orders. It depends on what way the case needs to go. If one parent feels aggrieved that they're not having time with the children in accordance with the orders, of course they need to get legal advice, and they may actually then need to bring an application to enforce the current orders that are in place. And it's, I guess, possible that if that goes ahead, the other parent, the one who has care of the children and may not be supporting the children to attend the time that's in the orders, then that might be something that the parent who isn't doing the right thing might say, well, there's these reasons the children don't want to go, I can't enforce that, and so that could take place in the enforcement space. And it's also, as I said, a potential question about at what age does the court, allow the children's wishes to be determinative. And as I indicated in the poll, that actually really depends on the circumstances of the family, whether there are concerns about risk, whether if in enforcing the orders there might be concerns about risk for the children potentially you know, taking things into their own hands and putting themselves in an unsafe situation by potentially running away. So that's a very complicated question that it's really difficult for me to answer with any clarity. If there is a client who has that question, I'd suggest that they try to seek some legal advice, and the information that we've given around accessing legal advice through Legal Aid is probably a good idea for that client.
Okay, we do have time for more questions, so if you do have a question, I do encourage you to send it through. But in the meantime, I'll just move on to the next slide, but I'll keep an eye on my questions box. Sorry, I'll just go back. So on the screen now is just a list of our key phone numbers here at Legal Aid. So the first one, our 1300 6511 88 phone number, that's our main information line for legal information and referrals. So that's what we encourage the general public, and also support workers, carers who want to get in contact with us about their client to call that number. The next phone number, our Aboriginal and Torres Strait Islander information line, that's a priority phone line for First Nations clients. So if you have a First Nations client, please encourage them to use that number. The call will be answered as a priority in our call queue. And the last number there, questions about an application you have already submitted. So if you have applied for a grant of legal aid and you're waiting to check on the status of that, that 1300 383 900 phone number is the number to call for that one. I'm just going to check and see if we've got any more questions. Not at this stage.
I guess I can say a couple of things.
Yeah.
There was this government has passed this legislation. So this is the first of two pieces of change to the Family Law Act. So this legislation that we've just been talking about is mostly around changes to orders in relation to parenting and stuff around parenting and enforcement of orders around parenting. The second piece of change to the Family Law Act is coming. There's a further bill to amend the Family Law Act. The bill has not yet been presented to the Parliament, but consultation with all of the stakeholders has taken place. And that makes some changes to decision making regarding property settlement. And on my reading of the proposed bill, it is looking to recognise the impact of family violence and financial abuse in decision making regarding the division of property post the end of the relationship, as well as imposing some fairly strict duties around providing disclosure around financial matters, particularly in relationships where there was coercive and financial control. So that's the next stage of changes to the Family Law Act. And the other part of the legislation that's coming is also to regulate contact centres, so the centres where children attend where there's concerns around safety of the children with spending time with the other parent. So that's coming down the pipeline. Like I said, it's not really clear when that's going to be presented to the Parliament and when it's going to be passed. But it's part of clearly a suite of this legislation changing and maintaining the focus on safety of children and parties and recognising family violence and control.
We have had two more questions come through. Excellent. Okay, so the first one is, it refers to the process for where parenting orders have been made, but then post-order parenting plan and numerous failed mediations. Is it likely the court will see original orders as still binding other than the changes in the signed parenting plan?
Oh, that's a really difficult question to answer. Certainly if there are orders in place, but they do change it with the parenting plan, normally the court will pay some regard to the parenting plan and deciding whether or not the parenting plan has been breached will be something that no doubt each of the parties will have something to say about if it went back into court. So parenting plans can and do change orders, and it's really up to the parties to be able to demonstrate that you know, it was legitimately their intent to change the orders when they made the parenting plan. If that is a client who has that issue, again, I'm going to say, get in touch with us and set up a legal advice so that a solicitor can properly understand what the circumstances are and give that client some specific advice about those circumstances. And certainly it would be helpful for whoever gives that advice to be able to see the parenting plan and the orders and have a proper understanding of what the circumstances are.
Because I think the second question is a follow-up to that. So like they need to file a contravention application.
Well, yes, there is a case, I think, there for somebody to consider whether or not to bring a contravention application if the orders haven't been complied with. And, you know, harking back to what I said in the section around the contravention applications, the court has got a lot of tools to be able to try and resolve things at an earlier stage, like, you know, orders around make-up time and, you know, potentially making some small changes to the orders so that they work better, so that these sorts of issues are, you know, able to be resolved without long and ongoing expensive litigation. So for that client or that issue, I think it's a good idea for them to get some legal advice that explores all of the background as well as what the parenting plan and what the court orders actually say.
That's it for questions. Are there any other points you wanted to share or any tips? Because then I'll just roll on to some information about our CLE resources.
No, thank you for listening, and I hope that it's been helpful for you today.
Amazing. Well, we're about to wrap up, everyone. So just a couple of quick things. On our website, it's a great resource for free legal information about a range of legal issues. So get on there and have a look. There's heaps of information you can print out for clients. You can also order for free all of our publications. We've got over 80 publications on a range of legal issues, everything from fact sheets and brochures through to really comprehensive self-help guides, like stepping people through a legal process. They're all totally free. You can order them and have them delivered for free. So please, I encourage you to order those, whatever you need for your clients. We do run these webinars each month. So next month, we haven't released the date yet, but in late August, we'll be running a webinar on Legal Aid's Respect at Work Workplace Sexual Harassment Service. So stay tuned for that one. In September, because it'll be Child Protection Week, we'll also be running a webinar on some type of child protection matter, topic to be determined. So stay tuned for those ones. You can register for future webinars via our website, or if you're on our mailing list, I encourage you to sign up to our mailing list. And as I mentioned previously, all of our webinars are captioned and added to our YouTube channel, and we'll send the link to that in the email after this webinar is completed. So that's pretty much it. We're a little bit early, which is great. Early mark for everyone. Thank you so much for joining us, and we hope you got lots of useful tips out of that webinar. And thank you again, Marianne, for your time.
My pleasure.
Sharing your time. Thank you, everyone. I hope to see you at the next one. Thanks a lot. Bye-bye.